I'm Dr. Chitra Devi, Assistant Professor, Department of Commerce Professional Accounting, VB Vaniya Perumal College for Women. So in this video, we are going to see a topic from the subject Business Law under Indian Contract Act 1872, Free Consent. Yes, let us see the topic. Yes, free consent. Free consent is an important essential element of Indian Contract Act. There will be many essential elements of a valid contract in Indian Contract Act. Free consent is also one of the important and essential element in the contract. If the free consent is there only, we can say the contract is a valid contract. So let us see what is a free consent. So first see what do you mean by consent? Yes, according to section 13, the act defines that the consent. What do you mean by the consent? Yes, the person is ready to accept. The person is agree. The person is willing to enter into the contract without any influence. So is agree to the contract. Okay, I am entering into the contract. So that is called consent. So in English law, we can say it is a consensus ad idem. So it is called a consensus ad idem. So this is the meaning of consent. Next. So this consent is not free when it is in the following situation. So why we can say, or when we can say, why that is the consent is not free. There will be many situations. So if the free consent is a coercion or misrepresentation or fraud, or either it is misrepresentation or undue influence or mistake. So if these cases are present, we can say the consent is not free. So everything has different sections. So free consent comes under section 13 and coercion comes under section 15. Then section 16 is undue influence, section 17 is fraud, then section 18 is misrepresentation, and mistake has section 20, 21 and 22. Okay, let us see the first one, coercion. So it comes under section 15. If any person giving the consent by anybody threatening or committing, or if you are anybody threatening you to enter into the contract means, so that contract is called by coercion. It is not a free consent because we are threatening the person to enter into the contract. The person is not willing, he is not willing to enter into the contract. With somebody influence, that is two or more parties, influence them, threatening them to enter into the contract. So actually that is committing or threatening to commit any act forbidden by Indian Penal Code. If you are threatening or if you are making the suicide to someone, it is actually forbidden by Indian Penal Code. That is, it is not punishable because we cannot punish the dead person. So it is forbidden by the Indian Penal Code. But under Indian Contract Act, if you are threatening someone to sign in the contract or enter into the contract, or if you are threatening to pay the money into the contract, that should be repaid. Yes, we can say it is an voidable contract. It is not a valid contract. It is called a voidable contract. So because one or more parties compel them, threatening them to enter into the contract. So the money should be repaid or to return to the specific person. We can see the example where husband obtained a release deed from his wife and son under a threat of committing suicide. The transaction was set aside on the ground of coercion, suicide being forbidden by the Indian Penal Code. So what does this example means? The husband is compelling the wife and the son to sign in the divorce, that is relieving from the family details. Okay. So the husband obtained a release deed from his wife and son. If you are not signing the contract, if you are not signing in this agreement, I will get suicide. So the husband is threatening the wife and the son for signing into the contract. So after that, because it is unvoidable, because by the threatening only they are entering into the contract. So the court forbidden by the Indian Penal Code, it is called as coercion. Yes. Then second one is undue influence. Undue influence comes under section 16. So what do you mean by undue influence? It is exist in the relationship because of they are using the relationship with an advantage. They are making the person to enter into the contract. For example, A having advance money to his son B. So A is a father and B is a son. So during his minority, A advances some money to B. So after that, B attaining the majority. B is a major now. So B is that is born from B for greater than some due in respect of the advance. A employs undue influence. So after that B is getting the majority, that is major. He is exploiting A, that is father, more money. So he is not giving back the money to A. So in this case we can say A employs undue influence. So the money should be paid by the B, that is son, to the father. So maybe it is only exist in the relationship, that is only we can say it is an undue influence. So what are the relationship we can say in this undue influence means? Yes, doctor and patient, advocate and client, parent and child, guardian and ward, trustee and beneficiary, master and servant, fiancé and fiancée, income tax officers and assessee. So with the relationship, if the person is influencing the other person, taking the advantage, for me you have to do this. So for that only, if you are doing something in the relationship, we can say it is an undue influence. So these are the effect of undue influence. It is also a voidable contract. It is not a valid contract if you are influencing somebody to entering into the contract. Yes, next one is fraud. It comes under section 17. Yes, what do you mean by fraud? Fraud means misstatement of facts. If something is false, you can say it is a false, but you are hiding the truth. So you are making them to believe the person, the statement is a true statement. Actually the statement is a false statement, but you are making the person to believe the false statement as a true statement. That is called a misstatement of facts. Your omission of law, you are hiding any truth, you are omitting the law and you are entering into the contract. So these are all called fraud. As example, A bought shares in a company on the faith of a prospectus which contain an untrue statement. Actually A bought some shares in the company. In the prospectus they have wrongly mentioned that B is a director of the company. So but A doesn't know about the who is B, he doesn't know anything about B, but he bought shares in the company. So after that he claims for damages in the case was dismissed because he doesn't know anything about B. So that is, this case was dismissed by the court in the Indian Contract Act. Yes, next is misrepresentation. It comes under section 18. So fraud is misstatement, but this is innocent misstatement. So wrongly, they are unaware of that. So that is called a misrepresentation. It's a false representation which is made innocently. Innocently, they don't know that. That's why they have told them. So without any intention. But in that case, fraud they have intention to hide the matter. But here misrepresentation, they do not have any intention to hide the matter. So innocently they did that. Innocently they have misstatement. They did the misstatement. Yes, here is also an example. A believed that he has already a motorcycle. So he is ready to sell the motorcycle to B. So A is believing that his motorcycle is in a good condition. So B is also believed the A statement and he bought the motorcycle from A. So on this statement, B bought that motorcycle and whose engine proved to be defective. After B bought the motorcycle, the engine, he knows that the engine was defective. Here A statement, because A is believing his motorcycle is good in condition. So that's why he sold to B. So it is not a misrepresentation. Yes, last one is mistake 19, that is section 19, 20 and 21. Mistakes are classified, that is categorized into two divisions, mistake by law, mistake by fact. First one is mistake by law as per Indian law and as per foreign law they have explained. Then mistake of fact on the bilateral mistake and unilateral mistake. First we will see mistake of law, Indian law. As per the Indian law, if A and B enter into the contract on the erroneous belief that they doesn't know about, they doesn't aware of the law, they enter into the contract, means the contract is not voidable. We can say it is a valid contract. The next one is mistake by foreign law. In foreign law, we cannot say they doesn't know that contract, they doesn't know the details of that, they doesn't know the act. So that's why they enter into the contract, means we can say it is a void, it is not voidable. Last is bilateral and unilateral mistakes. So bilateral means both the parties do not have any awareness, they have confused about the facts. Both the promisor and the promisee, both the person have confused about the facts. That's why we can, that is, they made a common mistake. So that's why we can say it is a bilateral mistake. So that will be another name for the bilateral mistakes, that is common mistakes and mutual mistake. Another one is unilateral mistake, only one side, either promisor made mistake or the promisee made mistake. So if the one of the parties to an agreement is made mistake, we can say it is a unilateral contract. So these are the that is not considered in the free consent. Thank you.